Shoplifting. Did you know that you don't have to leave the store to be charged? Hi, my name's Dale Savage and I'm a criminal defense attorney here in Charleston, South Carolina. And today we're talking about shoplifting. That's right, in South Carolina, it isn't a requirement that you leave the store or you even go past the point of sale to be charged with shoplifting. What our statute requires is that if you take possession or cause another person to take possession of merchandise with the intent to deprive that store of the full value of that item, then you can be charged. And you don't even need to deprive the store of the total value of the item. If you alter the tags, switch the tags, or modify them in some way, and you even pay for the item, but it's not the full price that was displayed on that item, then you can be charged with shoplifting as well, because you've deprived the store of the full value of that item. So as you can see, the statute is pretty broad. And there are three categories of shoplifting, and it depends on the value of the merchandise. So, if the value of the merchandise is less than $2,000, it's a misdemeanor offense, and you're looking at a charge in magistrates or municipal courts, and it's a 0 to 30-day offense in jail, and it carries a fine up to $1,000. If the value of the merchandise is between $2,000 and $10,000, that's a felony charge, and you're looking at up to 5 years in prison. If the value of the merchandise is greater than $10,000, that's a felony, and you're looking at a felony charge that's up to 10 years in prison. One important side note is that if you are facing a shoplifting charge and the merchandise is less than $2,000, your case still can be enhanced to a felony charge of up to 10 years in the circumstances where you have 2 prior convictions for property theft. And because you are a repeat offender, then they can enhance it to what's called a property offense enhancement. And that means you're looking at up to a 10-year felony, even if the value of the merchandise is less than $2,000. So how do we deal with these types of cases? Typically, you're dealing with 2 types of scenarios. One, where intent is an issue in the case. And the second one is where the state just has a really good case against you. An example of where intent may be an issue really is a reflection of our modern day society. And for example, I've had a case once before where I had a client that was in a store looking at merchandise. They picked it up. It was an item of clothing, a top. They were looking at it. They received a phone call. They looked at their phone and they weren't able to get clear reception. So they had that item and the phone up to the ear, and they went up to the front of the store and they actually walked past the point of sale. But they didn't leave the store, and they maintained and stayed there talking on the phone. The loss prevention officer saw that, came down and grabbed the person and charged him with shoplifting. That case there, I was able to successfully argue that the person didn't have the intent to deprive the store of the value of that item. They were just merely talking on their cell phone and forgot that they had the item in their arm. So what do you do if you do have a case where the state has just really good facts against you? Well, you still have some options available to you. There can be diversionary programs that are available to you, and if you qualify for those and complete them successfully, that means that you're not convicted of the charge, and you can get it dismissed, and you can get the arrest expunged from your record. So, if you have a shoplifting charge and would like to explore your options, please give me a call at 843-530-7813. I hope this video was helpful, and thanks for watching.